a need for greater levels of technical assistance to companies on a lot of different fronts, and we are willing to support that with more resources going forward.
House Leader.
Madam Speaker, we move to the next statement.
Members, as we await the orderly, please make welcome to his feet for statement by Minister or House Leader and Minister of Agriculture, Fisheries and Mining. Members.
Thank you, Madam Speaker. Madam Speaker, for decades, Alpat has been one of the anchors of the Jamaican mining sector and one of the most important economic engines in Western Jamaica. Yes, it will be distributed. No. Yeah, I said in the soft copy. Apologies, Madam Speaker, the copy should have been set. Let me just, yeah. All right, so I ask the members, it will be provided in short order. And I'll send you a WhatsApp, Member Paul. Its operations have supported generations of workers, contractors, transport operators, small businesses and families across many communities, including Nain, Milesville, Junction, Malvern, Santa Cruz, Littis, and parts of southeastern St. Elizabeth and southern Manchester. Madam Speaker, when Alpat operates, the impact is felt far beyond the gates of the refinery. Shops benefit, transport operators benefit, service providers benefit, farmers and small businesses benefit, and entire communities benefit from the economic activity generated by its operation. It is for this reason that the reopening of Alpat is a central priority for this government and formed a major part of my trip to China recently. Madam Speaker, as members of this Honorable House will recall, Jikwon Iron and Steel Company, more commonly known as JISCO, acquired Alpat in 2017 and restarted operations after several years of closure. During that period, JISCO invested approximately US $360 million into the operation and created employment for approximately 1,000 Jamaicans, including direct employees and contractors, bringing renewed economic activity to the communities across that region. However, in 2019, operations were suspended. The impact of the suspension was significant, particularly for the workers, families, and businesses that had come to depend on the refinery. The suspension was further complicated by the COVID-19 pandemic, changing global market conditions, and wider challenges facing the alumina industry. Madam Speaker, over the last 5 years, JISCO has undertaken a comprehensive feasibility process to determine the most viable pathway to return Alpat to full operation. JISCO's technical teams assessed the existing plant, examined the investments required, reviewed modern technologies, and visited other jurisdictions to study approaches being used internationally to improve efficiency, reduce costs, and modernize alumina production. Following that process, Madam Speaker, JISCO has now determined the path forward for the reopening and modernization of Alpat. Madam Speaker, as part of this process, our engagement in China was focused on direct discussions with the key decision makers responsible for the future of Alpat. The delegation met with the leadership of JISCO to review the redevelopment plans, examine the remaining requirements for implementation, and discuss the steps necessary to return the refinery to productive operation. Madam Speaker, I had the opportunity to tour GISCO's industrial operations, including their aluminum refinery and steel smelting facilities. These visits provided first-hand insight into the scale of GISCO's operations, the technology being utilized, and the approach being taken to modern industrial production. Importantly, I was able to meet members with the board of directors of the GISCO Group, including the chairman of the group. And in those discussions, GISCO reaffirmed that Alpart remains a strategic investment opportunity and forms an important part of the company's wider international growth and recapitalization strategy. Madam Speaker, I express Jamaica's appreciation for the investment that has already been made, but I was
This is the type of faceless animated videos that helped us grow our channel 10 times in 2025. And we created this video in under 5 minutes with Toonbee AI. Just type your idea, and Toonbee turns it into a beautiful 2D or 3D animated video you can use for social media, YouTube, teaching, marketing, or content creation. No camera, no editing skills, no complicated software. In fact, I'm so confident you'll love it. You can try Toonbee completely risk-free. Use it, create videos, and if it's not for you, you get your money back. 60 days money-back guarantee. Sounds good? Click the button below and lock in your one-time access before this offer disappears.
The AI Toolkit is live on Dvid. Every leading AI tool you need for video creation is now organized for you. All that's missing is your story.
It's awake.
Get all the latest image, video, and voiceover models in one clean experience. So you can focus on what really matters, telling your story. Go to Dvid. Start creating without limits.
is tied to generations of work, enterprise, and opportunity. A matter that the member and my state minister from Southeast St. Elizabeth is very familiar with, having been the longest serving member on the Alpart Community Council. It has supported families, sustained businesses, and contributed to the economic life of those communities. Madam Speaker, as a part of the process, we also directly engage with the governor of the Gansu province and his team. It is important to understand, Madam Speaker, that GISCO is a state-owned enterprise, which is owned by the Gansu province, which means the provincial government plays a critical role in major decisions regarding investment, expansion, and long-term strategic direction. Therefore, being able to engage them directly was critical in relation to our discussions regarding Alpart. During our discussions, with the governor, we reinforced the importance of Alpart reopening. We emphasized the need for continued support to move the modernization program forward, and we also spoke about deeper relations in relation to Jamaica. I'm pleased to report, members, that the governor gave assurances that efforts will be made to facilitate the timely reopening of Alpart and encourage GISCO to move expeditiously towards restarting operations, recognizing the importance of the project to Jamaica's economic development and the continued partnership between Jamaica and the Gansu province. Madam Speaker, arising from those engagements, GISCO has now written to me and has confirmed that following our visit and its extensive feasibility process, it will proceed with a two-phase modernization program for the Alpart refinery. Madam Speaker, the objective is to restore Alpart as a modern, competitive operation, and a major player in global alumina production. GISCO's redevelopment plan is designed to return the refinery to a production capacity of approximately 2 million tons of alumina annually, implemented in 2 phases, with phase 1 targeting 1 million tons per year and phase 2 adding a further 1 million tons. Phase 1 represents an investment of approximately US $490 million and will focus on returning the facility to operation using newer, cleaner, and more efficient technologies. This investment will include the modernization of major operational systems, the upgrading of the plant infrastructure, the redevelopment of power generation facilities, the implementation of dry stacking technology for residue management, and the rehabilitation of the critical rail and port infrastructure. The company has committed to making every effort to satisfy the necessary preconditions to allow construction activities to commence before the end of this year, with the objective of an official launch before June 2027. The project in phase 1 will take 20 months to completion. Madam Speaker, the global alumina industry has changed, and the future of Alpart requires an operation that's more efficient, sustainable, and positioned to compete internationally. That is why in the modernization plan, it includes the introduction of advanced technologies and a 5-megawatt photovoltaic and energy storage hybrid system, positioning Alpart as a green, low-carbon demonstration project. The plan in phase 1 also includes the rehabilitation of the hurricane-damaged Port Kaiser, recognizing that the success of the refinery depends on strengthening both the plant and the critical infrastructure required to support efficient operations. Madam Speaker, the good news is work has already begun in key areas. GISCO has invested approximately US $8 million in new rehabilitation equipment, including 2 large D11 bulldozers, which arrived at Kingston on the 30th of May and have now been commissioned. The state minister was at the commissioning, and they are now out in the field leading the reclamation of mined-out lands, which has been a long-standing challenge that they are now working on. We have also advanced discussion on the long-standing issue of land titles for relocated residents. GISCO has advised that approximately 1,233 titles were required, with approximately 350 already completed. We're going to do another 50 during the course of this year, and then there's going to be an acceleration of the project utilizing the systematic land titling initiative. Madam Speaker, securing adequate bauxite reserves was also a critical part of the discussion. GISCO has indicated that approximately 149 million tons of bauxite reserves are associated with the lands currently being pursued, which would support the long-term viability of the refinery operations. So, Madam Speaker, in closing, I'm very happy that our discussions in China have led to some positive outcome. Jamaica values the partnership with GISCO, but we also recognize the urgency of action. After years of uncertainty, there is now renewed commitment, a defined modernization program, a clearer pathway towards returning this important facility to productive operation. Madam Speaker, this government made a commitment to the people of Jamaica that we would pursue every avenue to see Alpart return to operation. We went to China, we engaged decision makers, we secured a clear path forward, and we are closer now more than ever before to seeing the reopening of Alpart, to once again drive growth, jobs, and opportunity for our people. I thank you, Madam Speaker.
Thank you, Minister. The member from Manchester Northwest will respond.
Thank you, Madam Speaker. Let me say I hope that the minister had a safe trip, and I see that he's back. But, Madam Speaker, we have been hearing these timelines for a number of years now. In the minister's own presentation, statement to the House, it is over 5 years now that the plant has been closed. And we have heard missed announcement dates over and over again. And I just want to know what will make it different this time. Because if it is just a satisfaction that GISCO has sent 2 large earth movers here, bulldozers as the minister described them, as easy as they send them, they can send them back out and they can be parked. But Madam Speaker, I mean, we on this side hope that this time around that GISCO will act on the commitment that they have made. But I want to ask the minister, if GISCO misses the next deadline that they have committed to, and I would have hoped that it wouldn't have taken the minister and the administration 5 years to really hold GISCO to book on this one. But what action will be taken by the administration if GISCO misses the next deadline? Because we have been getting missed commitments from them over the last 5 years. Minister, I think that you have been a little bit soft on the industry itself, not just GISCO, but the industry itself when it comes to land reclamation and land titling. It is something that I think that we have discussed, not only in this last sectoral presentation, but I remember my sectoral presentation last year, the whole issue of land titling and land reclamation. And you made a commitment that you would deal with the issue, especially of land reclamation, and that you would come to the House with some amendments to the legislation that governs it in dealing with the issue of land reclamation. But the main issue is what will be the action of the administration if GISCO misses the next deadline. And, you know, they say better late than never. But I am happy to know that the minister decided to go to China in this instance to get a commitment. But I am not firm that this commitment holds any water until we actually see some action taking place at GISCO. So, Minister, my few words on that, but just the issue on what will the action be next is one that I would love to hear from you. Thank you, Madam Speaker.
Question from Manchester Southern. Any other members with questions? Any other? All right. So next will be the member from Kingston East and Port Royal, and finally the member from Clarendon Western, after which the minister will respond. No, call him first. So Manchester, the first would be Manchester Southern, and then Kingston East and Port Royal, and then finally Clarendon Southwest. Oh, your mic was on first. No need to turn it off.
Thank you.
Or you can.
Thank you for this update,
Keep it
Minister. You
Your turn.
mentioned in your speech
Turn it
that
off.
Manchester Southern is one of the constituencies that's most affected by, could you help me with it, Madam Speaker? This one doesn't see very well. Thank you. You mentioned in your statement, Minister, that Manchester Southern is one of the constituencies that has been most affected by Alpart's mining and refining activities and related activities. And in particular, I welcome the fact that we may see some action in terms of the accelerated reclamation of mined out lands, because I think this applies almost exclusively to the Manchester Plateau and Southern Manchester. When you answered questions in this house about 6 to 9 months ago related to Jamalco, and they are not observing the law in terms of reclaiming pits within time provided, you said you had a zero tolerance for non-compliance with the time set out for reclamation, and that your mining department had assessed Jamalco for fines. I don't remember the figure off the top of my head, but there were substantial fines. Can you give an update on whether those fines have been applied? Question one. Secondly, can you give an update on what is the status of fines for Alpart, who have much older mines that have not been reclaimed or rehabilitated? And can you give an update on that? Third is with respect to the 1,233 titles that are required. Again, Minister, you would understand that perhaps the lion's share of those titles relate to residents of South Manchester. So could you give, and I don't necessarily, I'm not asking you for details here, but could you commit to send the Member of Parliament in writing the areas for which this 350 already completed titles relate to, and a schedule for the balance of the titles? And finally, Minister, this 149 million tons of additional bauxite reserves that are associated with lands being pursued, could you say if any of those lands are in Southern Manchester? Thank you.
Member from Port Royal, Eastern Port Royal.
Minister, I have a few questions. Firstly, are there any tax concessions granted to GISCO for the investment that they are committing to do? And if you could provide details on any such tax concession. There has been a problem with dust in the Southeast St. Elizabeth constituency. Have you reached an accommodation with GISCO to resolve that dust problem for the people of that area? You mentioned that there were two D11s that were imported. My understanding is that the D11s are for land reclamation and not mining. So if you could just clarify that. Finally, did you reach any accommodation in relation to the use of the waste, the residue, for further processing? You have mentioned that you are committed to processing for rare earth. Was that a part of the discussions that you had? And finally, in relation to the 149 million tons, could you say if additional mining lands have been allocated and if these are anywhere near the cockpit country?
Minister, hold on. You have one other member before, and that's a member from Clarendon Southwest.
Thank you, Madam Speaker. Minister, in respect of the outstanding titles. You mentioned some 350 delivered, total of 1,200 in total. The question, Minister, is why would you consider systematic registration as opposed to vesting orders? The vesting orders, as we know, is provided for under the Bauxite Alumina Industry Special Provisions Act, and it is deliberately in place to fast track delivery of titles.
I just built a budgeting app.
What? How?
Base 44. Look, it pulls all our expenses into one place and breaks down spending by team.
Interesting. Can it generate reports?
It can now.
Nice. That's actually pretty good. If you're going for generic.
How about now?
Oh, that's much better. What about all of our files?
It's already connected to our drive and our mail and Slack.
You gotta send this to finance.
Interesting. But it needs editing permission by department.
Sure. Anything else?
Can this thing process invoices?
Can it show cost growth by category?
Is it password protected? Can it track spending trends? Only it could auto flag overspending.
Done.
Nice.
Orders as right now. In fact, I signed some last week. And we have been using vesting orders for a little while now. But the sort of speed that I thought the vested orders would have brought has not really materialized, right? Because there are still some challenges. So we've met with the companies, and we would only use systematic where it would speed it up, right? Clearly, systematic does allow us to sometimes cover a larger area, right? And because the boundaries are already well defined in these areas, the thinking is that it may allow us to move faster on a larger scale. But we're not abandoning the vesting order system. We're still doing it now. What we're trying to see is how can we speed up? Because again, as you know, a number of these people have been waiting on their titles for decades, for generations. But good question. We'll continue on that trajectory. To the member from Kids Studies Third at Port Royal, a couple of questions. So no, there is no contemplation of any bauxite mining in the cockpit country or close to the cockpit country at all. And as of this moment, no new lands have been ascribed or allocated to Alpat, right? They have identified areas in Manchester, and not in Manchester Southern, in more Manchester Northern. They have identified areas that they may be interested in that are proximal to where they already operate, right? Some of those areas, however, are already under mining leases, right? So they would have to go through a process if they are to take those lands. But as it is now, there's no new allocation, and definitely the cockpit country will not be contemplated at all. We had no discussions regarding rare earths or the use of waste. However, as you are aware, there is a local company that does have an exploratory license in relation to rare earths across a number of the waste spots, including Alpat's waste spot. And that company has been in discussion with the various companies like Alpat, like Jabalco, and the ministry in relation to rare earths and rare earths development. The bulldozers are for land reclamation, and it's in keeping with what the member from South Manchester indicated. We have instituted a zero tolerance approach. Now, the zero tolerance approach, as I said, is zero tolerance from where I've started, right? Because it would be very difficult. A number of the companies would have entered into arrangements, would have gotten concessions in the past from various ministers. So what I have said to the companies, and literally the Commissioner of Mines wrote to them to draw a line in the sand to say, as of all your pits must be completed within the time frame prescribed, right? I will, however, and I'm coming into your question, so let me just finish. In relation to the dust, a year and a half ago, GISCO implemented a system that has almost practically fixed the dust issue, right? To be honest, we have gone through now 2 dry spells with no complaints. And I had to commend them when I went there. I had commended the local team. They brought in some covering. So if you go into the Maysville area now, what used to be the waste pond is now covered with almost like a green shade cloth that acts as holding down the dust, right? We've been through 2 droughts. We're hoping it continues to hold. I have said to them, it appears because of wind, you have to keep replenishing the covering, but so far we haven't had any challenge. So that's a plus. GISCO was, there were concessions that were granted to GISCO upon the investment, right? A number of those concessions, they were not able to utilize because it had stopped, right? So at the time period when they stopped the operations, they basically had a 5-year concession. I can't tell you the details, but I can provide that information, right? And clearly, it is intended that, considering that they did not utilize that they would be able to utilize that in getting the plant back up and running, and that's important. In relation to South Manchester, so definitely I will send the details in writing regarding the titles, right? I would send the 350 that have already been given out, and also what's the sort of schedule, right? One of the things that we discussed with GISCO is to ensure that funds are allocated for this, so that as they move through the rebuilding, they are accelerating the pace of getting the titles. Because I've said to them quite frankly, one, it's their responsibility, but also in relation to goodwill, it will go a far way in the operations of the company. So I will provide that. I wouldn't have the information in relation to the fines, but I will check, right? I know some letters were sent out after drawing the line in the sand, and I will see how that went. But definitely in relation to Manchester Southern, I think you have seen that reclamation has started. Yes, there was a, well, you know, long-standing, and those bulldozers are going to speed up the pace in Manchester Southern. And clearly, as I mentioned, not only on some of the challenges, but once we get Alpra back up and running, Manchester Southern would be a big beneficiary. It used to provide a lot of the workers for the plant, and I know that has really taken a toll, quite frankly, on the communities in the area. The opposition spokesperson, it's a very good question, and it is true that there have been time frames in the past, right? We had a very, no, and I'll do the last year one. We had a very frank discussion with GISCO. And let me start with the most recent time frame. The most recent time frame is that they had indicated that they would start the reconstruction, rehabilitation phase late last year, December of 2026. They had said they were going to do 3 things. They were going to do a comprehensive asset verification, which they would hire about 300 people. They were going to restart land reclamation because they had finished land reclamation, as if they were doing the land reclamation, and that they were going to start exploring again, because it's very important that they get back out there to see where the quality of bauxite in the areas, and they would start the phase reopening. In fairness to GISCO, they did 3 out of the 4, right? So they started the land reclamation, they hired about 300 people for the asset verification, right? And they started the exploration. And people will tell you, they saw people in and around their homes testing soil, etc., etc. They had come back to us in December and said, with the damage done to Port Kaiser from Hurricane Melissa, they needed to rescope the reopening. It was at that time I felt it was critical that we engage at the highest level, because as you know, there is a bureaucratic process to get approval. So they have to go to the company, and then they have to go to the governor. And that's why we met with the governor as well. So I have been back now probably about 2 months, but I waited until I got their confirmation in writing in relation to their timelines and what they plan to do. So we don't have that. The question is, what action can we take? Two things. Well, clearly, GISCO would have purchased Alpat. So I think we have to be clear about that. That was a company-to-company transaction. They own the plant. However, the plant can't operate without reserves, without mining leases, and without mining licenses. And those still lay in the purview of the Minister of Mining and of the government. And I have been very clear with them. The truth is, we are now at a stage where I'm very sure other companies are very interested in existing mining leases. That's the stage of our bauxite industry. So they appreciate that if they don't act now, they may be unable to act at any other time. So we do have some levers that we can pull. And I disagree with you wholeheartedly. I think the record will show that the most reclamation and the speed of the reclamation has increased under our stewardship. I think the record will show that the speed of the land titling has increased under our stewardship, right? We have actually been a lot tougher on those items than before, right? And we are seeing the benefits. With that said, it's a long road to go because unfortunately, most of these titles, they are not new. In fact, since I've been minister, no community has been relocated for bauxite mining. All of these relocations happened decades ago. So while a lot is happening now, we have a lot to catch up on. So with that said, members, I know that we all want to see the action. And this announcement, while I'm very happy for it, I'll be happier when Minister Whittle and I and the Prime Minister can go to the formal launch of the reopening of Alpat. And I think all of us here should come. That is when we will again see. Before the next, I will say that. Anyway, thank you, members.
Thank you, Minister. Announcements?
Laid on the table of the House are the following: Annual Report of the Casino Gaming Commission for the financial year 2022-2023 and its Ministry Paper numbered 44 of 2026, titled Casino Gaming Commission Annual Report for the year ended March 31, 2023. Annual Report of the Casino Gaming Commission for the financial year 2023-2024 and its related Ministry Paper numbered 45 of 2026, titled Casino Gaming Commission Annual Report for the year ended March 31, 2024. Annual Report of the Integrity Commission for the financial year 2025-2026. The Insurance Amendment Regulations 2026 under the Insurance Act. The Pension Superannuation Funds and Retirement Schemes Investment Amendment Regulations 2026 and its resolution under the Pension Superannuation Funds and Retirement Schemes Act. Integrity Commission's investigation report into concerns that Ms. Janet Cunningham, a Chief Internal Auditor, formerly employed to the Cannabis Licensing Authority, failed to file her statutory declaration with the Commission for the year 2023 contrary to law and notice of its indicative rulings. Integrity Commission's investigation report into concerns that Ms. Octavia Ming Campbell, a procurement officer formerly employed to the Cannabis Licensing Authority, failed to file her statutory declaration with the Commission for the year 2023 contrary to law and notice of its indicative ruling. Auditor General's Department certified appropriation accounts under Head 20011 Recurrent Accountant General's Department for the year 2016-2017, Head 2000 Minister of Finance and the Public Service for the year 2022-2023, Head 20000 recurrent, Minister of Finance and the Public Service 2022-2023, and finally Head 56000C capital for the Minister of Science, Energy and Technology 2022-2023. Thank you, Madam Speaker.
Thank you. Bills brought from the Senate, petitions, papers, reports from committees, notices of motions given orally. I'll start with the exemption motion. Okay, you may go ahead, Minister.
Thank you, Madam Speaker. Madam Speaker, I beg to give notice that at the next meeting of the House, I'll move the following motion. The Pension Superannuation Funds and Retirement Schemes Investment Amendment Regulations 2026 Resolution. Whereas Section 58(1) of the Pension Superannuation Funds and Retirement Schemes Act provides that the Financial Services Commission may, with the approval of the Minister, make regulations providing for such matters as may be necessary or expedient for the purposes of the Act, and without prejudice to the generality of the foregoing. The regulations may contain provisions in relation to all or any of the following. A, registers to be kept for the purposes of the Act. B, provisions to be contained in a trust deed and plan rules or master trust deed. C, any other matter required by the Act to be prescribed. And whereas Section 58(2) of the Act provides that regulations made under Section 58(1) shall be subject to affirmative resolution. And whereas the Financial Service Commission, with approval of the Minister on the first day of July 2026, made the Pensions, Superannuation Funds and Retirement Schemes Investment Amendment Regulations 2026. And whereas it is desirable that the Pensions, Superannuation Funds and Retirement Schemes Investment Amendment Regulation 2026 be affirmed. Now, therefore, be it resolved by this Honorable House as follows. This resolution may be cited as the Pensions, Superannuation Funds and Retirement Schemes Investment Amendment Regulations 2026 Resolution. 2, the Pensions, Superannuation Funds and Retirement Schemes Investment Amendment Regulations 2026, which were laid on the table of the House on the 7th day of July 2026, are affirmed. Thank you, Madam Speaker.
Thank you, Minister. House Leader.
Madam Speaker, I beg to give notice that at the next meeting of the House, I will move the following motion. Whereas subsection 1G of section 41 of the Constitution of Jamaica requires a member of this Honorable House of Representatives to vacate his seat if any firm in which...
This is a song about a sleepy monster.
Look at my little Leo stomping down the hall.
Can I be a better astronaut tonight?
Sure, let's make it sound like we're in space.
Oh, my little Leo, flying.
Sutter is a shareholder and or director and or manager at Proven Group Limited, its subsidiaries and associated companies. And whereas these entities may from time to time enter into contracts with the government of Jamaica and its affiliated agencies, and whereas the member has disclosed his interest in these entities, be it resolved that this motion be referred to the Ethics Committee of the House of Representatives for consideration and report. Madam Speaker, I further beg to give notice that at a later stage today, I will move for the suspension of the standing orders to enable me to take this motion. Madam Speaker, I beg to give notice that at the next meeting of the House, I will move the following motion. Be resolved that the Insurance Amendment Regulations 2026, which were laid on the table of the House on the 7th day of July 2026, be referred to the Regulations Committee of the House for consideration and report. Madam Speaker, I further beg to give notice that at a later stage today, I will move for the suspension of the standing orders to enable me to take this motion. Madam Speaker, I beg to give notice that at the next meeting of the House, I will move the following motion. Be it resolved that with reference to the resolution approved by this Honorable House on October 21, 2025, appointing an internal and external affairs committee, that the name Zulika Jess be removed from the membership of the committee, and that the name Yvonne Shaw be substituted therefore. Madam Speaker, I further beg to give notice that at a later stage today, I will move for the suspension of the standing orders to enable me to take this motion.
Thank you, House Leader. No. Yes. Questions and answers to questions. Time being.
Madam Speaker, with the time being 3:42, I now move that the House be allowed to answer questions at this time.
Those in favor?
Aye.
Those against? The ayes have it. Member Paula?
Madam Speaker, I just got a memo from the Minister of Energy, who is quite appropriately recognized that I need to give approval. He is not well, and he therefore has promised to have the questions answered next week. So as a reasonable member, I am acceding to his request.
Motions that may be made at the commencement of public business requiring notice, motions relating to the sitting of the House, motions for leave to introduce bills, presentation of bills without leave of the House first obtained, public business. House Leader.
Madam Speaker, firstly, let me join in welcoming the members of the Sam Sharp Teachers College, a wonderful educational institution. Have produced some excellent teachers. Excellent teachers. I see Member Malahoo Fort beaming with pride. Yes, very, very good institution. And I see Member Bartlett claiming them as his children, his students. But wonderful institution. I'm very happy that they're here and they would have been able to see some of the proceedings. We're not finished, but now we're in public business, which is normally the time that I would have to give my remarks. I will also just welcome Member Malahoo Fort back to the House. I know we have all shared our condolences, but it's really good to have her back. And we continue to pray for your strength in these difficult times. I know, but she moved so quickly. All right, in public business, Madam Speaker, we're going to take our motions. We have some motions that we just, when I'll allow the Minister of Finance to go first, then I'll take my motion in public business, or I'll take my motions then. And then we're going to conclude the debate on the Mediation Act. So I know the Minister of Justice opened the debate, and I'm very sure there are members who want to participate. So allow me first to take these motions in public business. So, Madam Speaker, I now ask for the suspension of the standing orders to enable me to take the motion, those of which I gave earlier, in relation to the Internal and External Affairs Committee and the substitution of members.
Those in favor?
Aye.
Those against? The ayes have it.
Madam Speaker, I ask that the motion be approved.
Those in favor?
Aye.
Those against? The ayes have it.
Madam Speaker, I now move for the suspension of the standing orders to enable me to take the notice in relation to the insurance amendment regulations being referred to the regulations committee.
Those in favor?
Aye.
Those against? The ayes have it.
Madam Speaker, I ask that the motion be approved.
Those in favor?
Aye.
Those against? The ayes have it.
Madam Speaker, finally, I move for the suspension of the standing order to enable me to take the motion in relation to the referral to the Ethics Committee for the Member of Parliament for Manchester Southern,
Those
notice
in
of which
favor?
I gave earlier.
Those in favor?
Aye.
Those against? The ayes have it.
Madam Speaker, I now move that the motion, those of which I gave earlier, be approved.
Those in favor?
Aye.
Those against? The ayes have it.
Madam Speaker, we will now continue the debate around the Mediation Act.
No, Minister would have opened already.
Yes.
So,
So
Minister,
we'll now continue.
it will be a continuation. House Leader, do you have a listing of persons who have indicated they would like to contribute?
I know on our side, Member Tufton, Minister of Health, and Member Dalrymple Filbert plans to contribute to the debate. And Member Zuleika Jess, the leader of the opposition, plans to contribute. So I don't know if Member Jess wants to start us off since the last presentation. Doctor, okay. Minister of Health.
We will first take, rising to his feet to make contribution to this debate, the Minister of Health and Wellness. Minister Tufton, could you turn your mic on, please? Make him welcome.
Thank you very much, Madam Speaker, colleagues. Madam Speaker, this bill, the Mediation Act 2026, is very important from a health and wellness perspective, and it is in that context that I rise to support the public health imperatives and offer full support, and indeed to commend the Minister and Minister of State and his team for putting this bill together and advancing it in this House. I would like to reference, in making the point and supporting the bill, violence, particularly violence against our women, but generally violence within our society. Jamaica is a high trauma society, and a lot of it is influenced with our behavior, Madam Speaker, colleagues. And unfortunately, much of the cases we see in accident and emergency, which leads to doctors and nurses and other health practitioners' attention, is caused by decisions that we make, and in some instances, decisions that are against each other. We see some of this, Madam Speaker, through police reports. We see some through signs, whether it is physical, mental, or psychological. But in all cases, more often than not, the solution lies with some sort of public health intervention. While acts of domestic violence often occur behind closed doors, there are consequences that extend far beyond the home, affecting families, communities, of course, health services, the workplace, and the justice system. On a typical week anywhere in Jamaica, in our A&E or in some doctor's office, there is some treatment being meted out because of this type of antisocial behavior. And the reason why this bill is important, Mr. Speaker, is because these issues don't just occur. They start sometimes as a small, simple disagreement, and because of one reason or another, they escalate, and they escalate, leading to the injuries that are as a result of domestic violence. So what may be a minor disagreement, whether it is over possession, intimate relationships, relationships generally, children, or otherwise, these unresolved disputes do escalate, and that's the history, unfortunately, of our community and our country. And the data supports that. In 2024, a total of 33,081 injuries were recorded through the Jamaica Injury Surveillance System. And of these, almost 7,000 were violence-related injuries. Particularly concerning are the findings related to women. And I want to reference that. In 2024, just under 2,000 cases of violence against women were treated at a hospital somewhere in our country, or health center, meaning the attention that a doctor or nurse has to mete out, not to mention the pain and the suffering that those individuals, in this case, our women, have to suffer. And the data is also supporting that the ages between 18 and 40 account for some 74% of these cases. Because of how the bill is structured, it allows an opportunity to deal with these issues early at the level of the community, whether through community leaders, through the mechanism that is created by this bill, hopefully to become law, to avoid these circumstances before they escalate, leading to a strain on the health system and the pain and the suffering which results. Madam Speaker, men are impacted too. The 2024 survey from the Jamaica Injury Surveillance System supports this fact. Some 2,593 violence-related injury among men, and almost 35% of that is represented through intimate partner relationships. In the case of women, it's higher. It represents some 74%, almost 75%. So men are impacted like women, but women are more impacted. And it's worth mentioning. Women are the backbone of our society, our communities, and our families. And as a government, we must do what is necessary to protect them and to give them the support that is necessary. Madam Speaker, in public health, therefore, we support the mediation bill that offers an opportunity to change that narrative by creating a structured framework through which disputes can be resolved before they become a crisis. We accept and recognize from our experiences that these disputes start small, starts in the family, in the community, more often than not between persons who know each other, and then without the appropriate intervention escalates to become a criminal investigation, an emergency medical situation, tensions escalate, and indeed people lose their lives, starting with very simple disputes. It is within that context, Madam Speaker, that we support the bill and think it is important and indeed should have existed for a long time, but there's no time like now. I want to just reference a few sections, Madam Speaker. Section 60, Clause 2, and Section 61(2) promotes intervention through community, family, and domestic mediation. And this is where my focus is, because I think we in health tend to address some of these issues purely from a health perspective. So we have nearly 5,000 health officers, whether they are vector control workers, destroying mosquito breeding sites, or community health aides checking with the aged person in a household, whether they take their medication or giving them support, or the public health nurse or doctor. But we also have a mechanism under mental health, the Problem Plus program that trains community leaders to support mental health issues. And mental health is also a big cause of violence between individuals at the level of community. And so we have started to address that. And so we are interested to be supported by this bill to become legislation, because wherever there can be integration to support that, it would add critical value to managing cordial relations in the community between families or friends, as the case may be. And the bill, through Section 60, Clause 2 and Section 61, to promotes that type of intervention, which means that health can play a role in this regard. Section 62(1), the bill empowers the minister to make regulations for the implementation of community mediation, while Section 61(1)(a) and 62(a) and (c) empowers the mediation board to make rules governing domestic and family mediation measures. These provisions, Mr. Speaker, facilitates the development of accessible dispute resolution mechanisms within communities, enabling conflicts to be addressed by trained and impartial mediators before they escalate into confrontation, police involvement, or litigation. Section 61(3), Madam Speaker, we support. Clause 3, encouraging voluntary participation and cooperation pursuant to 61(3), where the bill promotes consensual dispute resolution by allowing parties to engage in constructive dialogue.
You don't have to pay upfront just to get your music on streaming platforms. With Rude Note, distribution is 100% free from your first release to your 50th. We help independent artists like you get their music on Spotify, Apple Music, and more without subscription or release fees eating into their budget. That frees you up to spend your money where it really matters: promotion, ads, content, and growing your audience. On top of that, with our free plan, you get to keep 85% of your royalties, and you always stay in control of your music. Root Note was built for artists who want flexibility,
And Section 42(2) and 42(3) reserves that right, or preserves that right, Madam Speaker. The other section that is worth noting, which health focuses on significantly, is Section 50 to 54, which speaks to confidentiality in resolving disputes. Health data is highly confidential. We spend a lot of time ensuring that it is preserved, that type of information. And the bill clearly outlines in this section the confidentiality of information. And the final section, Mr. Speaker, 48(2), enabling court enforcement of agreements, is also worth noting, because to the extent that the bill becomes law and a resolution is agreed on, this agreement is enforceable by law. And that gives teeth to community-based intervention and community-based resolution. And from a public health standpoint, what it means, Mr. Speaker, is that we can in fact attempt to address those issues at the community level. So, Mr. Speaker, that is my contribution to this bill. We think that from a public health perspective, it is important. It adds value to the work that we do at the level of communities, and it offers another buffer, another important intervention to reduce the potential for domestic violence, which creates added pressure on our public health system. Mr. Speaker, thank you very much.
Anybody from the opposition? I mean, they indicate long time. A member from St. Elizabeth Northeastern.
Thank you. Thank you, Mr. Speaker. Mr. Speaker, on this side, we welcome the mediation bill and approach this debate today with a view to actually see how best we can contribute towards strengthening the bill. And I see the member from Northeastern St. Andrew looking at me quite keenly. And so I wish to make it clear, Mr. Speaker, that our intent and our approach this afternoon is not to obstruct, but rather to construct or reconstruct in some cases. Mr. Speaker, we understand and we share the view and the vision articulated by the minister. We agree that mediation is indeed an ideal course of action to heal the wounds that divide our society. We know that this bill actually goes extremely far, not just deals with mediation here at the local level, but also encompasses international mediation. Against that background, it is important that we view this bill, Mr. Speaker, with a critical eye and to see how best we can lend our various expertise into making this bill as robust and strong as we possibly can. And so against that background, I trust that the House will be minded to view my suggestions and my recommendations in the spirit in which it is intended, Minister. And I start with the interpretation clause of the bill. At page 4, clause 2 speaks about, forgive me, Mr. Speaker. Clause 2 speaks about an individual who is habitually resident in Jamaica being permitted to access mediation under this particular bill. And I'm referring to the section that defines domestic mediation. Domestic mediation is actually defined as relating to a dispute arising out of a legal relationship where a party is habitually resident in Jamaica, amongst other things. My suggestion is that we should amend this particular clause to substitute ordinarily resident instead of habitually resident. And my position, Mr. Speaker, is very simple. In legal terminology, as the minister would know, the test to establish whether an individual is habitually resident in Jamaica is a much stricter legal test that needs to be satisfied, as opposed to where an individual is simply required to be ordinarily resident. And the truth is we have a number of Jamaicans who divide their year into living here in Jamaica for part of the year and another part in another jurisdiction. By this definition, we would be precluding and excluding those categories of Jamaicans from being able to benefit from this act, or rather from this bill, because we are insisting that they must be habitually resident in Jamaica. And so my suggestion, Mr. Speaker, is that the word habitually resident be amended to instead reflect ordinarily resident. And that can be carried over into a similar provision at page 5, clause B, which also makes reference to habitual residents. My rationale is the same. Secondly, at clause 11.2, I'm not sure if there was an oversight or if it is that we intend to embark on a course that is being pursued by some more modern or advanced democracies. But I note that we have created a summary offense at clause 11.2, but the penalty is only stated as being a fine. It doesn't include what should happen in default of payment. And we do understand that not everybody will have the funds to pay $1 million. And so I'm of the view, Mr. Speaker, that it is good practice, Minister, and we've traditionally done this in our legislation where the default prison term is actually included in the specific act. And so my suggestion is that we should make a decision as to whether we are going to be consistent, because in the other provisions I note where there is provision for a fine, a maximum fine of $1 million, in default 6 months. Here at 11.2, there is no provision for what should happen in the event that the fine is not or cannot be paid. So my suggestion is that that clause also be amended just to include what should happen in default of payment. At clause 12.1a, it speaks to eligibility to become a mediator. And I note that in order to qualify to be registered as a mediator, one needs to have attained the minimum age of 21 years old. I'm of the view that in this modern dispensation, that age limit could appropriately be reduced to 18. And the reason for that is very simple. And it's not just because some of us are more mature at 18 than some 21-year-olds are, but it is about equality before the law. And I note when I look at the entire bill, there is a schedule, Mr. Speaker, the 4th schedule actually allows for mediators qualified in other countries to be allowed to practice as mediators here, even if they are below 18 or under whatever age they're allowed to practice that in their country, they can come and practice in Jamaica. And at the same time, you would have Jamaicans who would not be able to practice as mediators because they have not attained that age. So as a matter of equality before the law, and also if we are looking at seeing how best we can assist, especially those younger ones with employment opportunities, this is a nice way to transition them into formal employment. And so my suggestion and recommendation is that we reduce the age from 21 years old to 18 years old. And finally, and I've given this one some thought, but I am hopeful that we might be bold and transformational. One of the biggest challenges that we've had in the justice system centers around the backlog. And yes, we appreciate the strides that the Chief Justice, the courts, and indeed you as Minister, forgive me, and indeed the Minister has actually done in bringing our numbers down, but we're still not where we need to be. We still have a 54% case backlog as it relates to civil court cases. My concern, Mr. Speaker, is that this bill provides that once a mediation agreement is signed, one party has to go back before the court to apply for it to become binding a binding court order, so to speak. My view is that we don't need to reinvent the wheel. There is ample precedent in our neighbors in the Eastern Caribbean, for example, where they have an automatic conversion model that allows for once a mediation agreement is signed, it is automatically converted into a final order issued out of the court. So there's no need to formally go back before the court, apply for it to get that particular status. It automatically converts upon registering the mediation agreement in court. In other words, all you have to do is file it in the registry. There's a specific registry designated for mediation agreements. Just like you have probate registries, etc., you have a mediation registry, an expedited registry. Once you file the mediation agreement in that registry, it automatically takes on the legal weight of a final binding court order. That means that individuals don't have to go back before the court if there is a breach of the mediation agreement. It means that you're not contributing to the backlog and you're actually seeking and implementing ways to speed up justice. And so, against that background, those are my brief suggestions for the improvement of this bill, and I hope that this House will give due consideration. Thank you.
Member from St. Andrew. Member from St. Andrew Western.
So, Mr. Speaker, I want to congratulate the minister and his team for finally bringing this piece of legislation to the House. Because when the Arbitration Act was brought in 2017, I think, I thought that shortly thereafter, there would have been the submission of the Mediation Act. It has been quite some time, and I believe that there is the need for international mediation, especially in the area of commercial matters, cross-border commercial matters. The Arbitration Act really relating to the New York Convention that addresses arbitration in a particular way. The mediation is a part of it. But more generally, I wondered, Minister, I didn't see, it wasn't clear what the interaction is will be between the reform in arbitration and the mediation, because we're looking at alternative dispute resolution. And I wonder if there isn't an opportunity to include in that mediation, conciliation, and arbitration, because they're part of a spectrum of alternative dispute resolution that we are seeking to reform in Jamaica. And it's not clear to me what the relationship is. Okay, but yeah, if you could point that out, because it's not very clear to me what that would be. Because I think conciliation, there is, if you don't address it in this way that include conciliation, then issues like labor relations and conciliation proceedings in labor relation, there could be some lack of clarity around that. The other matter I'd want to comment on is really the enforcement provision for confidentiality and enforceability, because
this is the type of faceless animated videos that helped us grow our channel 10 times. And we created this video
between conciliation and mediation, arbitration. because it's one continuum, and we're trying to incorporate alternative dispute settlement as one mechanism. So I don't know if that was thought through and how that is addressed specifically and decided on. All right? But I believe that this is necessary, particularly in the area of commercial matter, trade, investment matters. The cross-border settlement, the Singapore Convention is now proven. I think there's a track record there that we could follow. My other concern is really the training. I know we have done some work and we have some institutions already set up. I think the two that the Mediation Center and one JICA, International IAIC, they're really part of the Mediation Center. But what about the training of mediators as opposed to arbitrators? And I know we've done some work in arbitration, but I think we'll need a bench, a deeper bench of mediator to address that. But I think overall, I think it's a long overdue step, and I think it will enhance the environment for international dispute resolution in Jamaica and the ecosystem for overall alternative dispute resolution. Thank you.
Member from St. Anne's South Eastern.
Mr. Speaker, I was at Sabbath school and they read from Matthew 18, verses 15 to 17, which actually sets out a process for mediation. At first, you don't get satisfaction from talking to the one who offends you. You talk to someone else, you go to the church, and then you find a neutral party. So mediation is as old as the Bible, we could argue. And we do want to preserve that traditional practice. However, when we look at the bill, clause 9, it says we should not practice mediation if you are not registered. And so it makes me wonder then if the real intent here is more around professional mediation, because 9B speaks to the fact that about payment. Hence, I would suggest, Minister, that we consider revisiting the objects so that object A, 3A, which says regulate the conduct of mediation, be reworded to speak to the regulation of the conduct of professional mediation. And in so doing, we are able to allow the traditional practices, and in the way that the Minister of Health spoke about the role, for example, of the CHAs, that would be allowed, right? They would not be violating the law when it becomes law if they're doing so. So that's my my suggestion here, that we have another look at object 3A and consider narrowing it to professional mediation.
Member from St. Andrew Southern.
Thank you. Thank you, Mr. Speaker. Mr. Speaker, I join with the comments made by the member for St. Andrew Western on the benefits of encouraging international mediation being conducted in Jamaica. In the same way that when the arbitration legislation was brought here a few years ago, I strongly endorsed it as a simple and coherent code for arbitration in Jamaica, which was consistent with the aspirations of those who wanted Jamaica to become an international center for arbitration. Unfortunately, we haven't seen that happen yet, but the law that we have on arbitration is, in my view, a very good law, and provides an excellent legislative platform for that to emerge if other forms of support for such a center are created. And similarly, in the area of mediation, I think there are opportunities to do that as well. So that aspect of it, I'm very comfortable with. What I'm not so comfortable with is the idea of regulating mediation generally in Jamaica, domestic mediation generally in Jamaica. Regulation comes with costs for those who are regulated. There are fees that have to be paid, there are processes that have to be complied with, there are enforcement costs if it's going to make any kind of sense, and so on. It isn't clear to me what mischief or imperative there is for bringing the practice of mediation domestically into that regulated arena. We've had mediation operating certainly in the court system, mandatory mediation in the court system for civil matters for many years now. And that hasn't, as far as I'm aware, as a former minister of justice, thrown up any need to regulate mediation activities, perhaps. And then I thought what we would be trying to do is encourage more mediation in the parish courts, including in the criminal matters, which would help to relieve some of the caseload burden from those courts, and is in keeping with the overall thrust through child diversion, restorative justice. You know, it's all part of a kind of strategy to encourage other forms of settlement of disputes other than through trial of matters. And I know that's something that you endorse. So I am mindful, for example, of what happened when the former Minister of Finance brought legislation here which sought to and has brought corporate services and trust services under the FSC. So you now have to be licensed by the Financial Services Commission to provide corporate services or trust services. That was never the case before. The effect of that has been that many law firms no longer offer those services. They have completely withdrawn from those services because the costs and burdens of operating in an FSC regulated environment, those are excessive and onerous to their practice of law, which is already regulated by the General Legal Counsel for anti-money laundering and other such activities which we know are very sensitive matters for Jamaica. So in light of that history, where we have seen the effect of imposing new regulation on persons that were not previously regulated, sometimes doubling up in the case of lawyers who are regulated by the GLC, and if they want to form a company for a client, they have to be registered by the FSC, licensed by the FSC to do that, which is, many practitioners feel is excessive and onerous and unnecessary. So from that perspective, I'm very wary of imposing any kind of regulatory burden on domestic mediation practices. I think that would be counterproductive if it was to act as a disincentive for people to participate in mediation services. And while I do think there's importance to having persons who are mediating legal disputes which are under the jurisdiction of the court to have some certification, as you've pointed out, and that is already the case, imposing a new regulatory regime on domestic mediation took me by surprise. I wasn't expecting it when you brought it here. I thought this would have been really focused on being the complement of the arbitration legislation that we have, which really has set the platform for Jamaica to become an international dispute resolution center, with arbitration and now mediation being another arrow in the quiver, so to speak, which would be an enhancement of the overall array of services that can be provided to companies here and abroad and cross-border transactions and so on. So those are my thoughts. I have a concern because I've seen the effect, the chilling effect, the disincentive effect that introducing regulation in areas which have historically not been regulated and aren't really crying out for it from any domestic needs can have on their willingness to provide those services. And I'm concerned that we may have that impact in relation to mediation.
Member from St. Andrews South, Western.
Thank you very much, Mr. Speaker. Miss, oh, yeah, thanks. Mr. Speaker, I had wanted to make just a few comments in relation to this bill. And I am grateful for the comments from the member from St. Andrews South, because it is akin to some of the concerns that I have. So I know that for several years, we have been encouraging a culture of mediation in Jamaica. And that includes all other kinds of alternative dispute resolution processes, as well as restorative justice and so on, as you very well know. I would hate to see, well, certainly I was hoping that the bill itself, apart from the certification and stuff that's required, would actually speak to building that culture of mediation. We have done a fantastic job across administrations, for example, with peace and love in schools, which is really what it's also about, this culture that we are building. I was hoping that we were conscious that there are individuals right now who are trained but not necessarily certified mediators who play a significant role in several communities, whether it is in church, as the member from Southeast St. Anne's said, or in communities. And for what they are doing, they certainly would not need to be certified, since they have absolutely no interest in participating in the court system. Because of how Jamaica is, I am fearful that some of these individuals who are doing good and mean well might at some point run into afoul of the law because they are practicing. Yes? No, and so, right. And so I want to make sure that these safeguards are there, because you know how it is. You know, police come and see a couple youths doing a session, and they say, no, Parliament passed a law, you have to be certified, where's your certification? So I want to make sure that we are also mindful that it's not just in the courts that these things take place. They take place in communities, and persons who are engaged in those activities need to feel comfortable and that they are also protected as we move to professionalize mediators.
Member from Hanover Western.
Mr. Speaker, I want to endorse the comments made by my colleagues. I wish to comment on section 32(1), where it speaks to when mediation commences. What I'm not seeing is for court-referred mediation, whether or not there's a time period for those to be completed. And mediation for me should never become another waiting room in the justice system. And so I think it requires some specificity as to when, especially for court-referred mediations, when this should complete. This, the legislation really is intended to reduce delays and backlogs. And if you don't have a specified time, then there will be the tendency for it to continue without an end. And so it should establish clear expectations of timelines within the legislation. That's my contribution.
Member from Trelawney Southern.
Thank you very much. Yes, if I can.
Thank you very much, Mr. Speaker. I first of all want to thank the members on the other side for their contributions, valuable contributions, and a number of them can be incorporated as we get into community stage, because indeed it does appear that there is generally full and good support for this bill. I rise too to support the bill, and I want to pause to commend the Minister of Justice and Constitutional Affairs for his stewardship in bringing this important piece of legislation before the House at this time. The bill, Mr. Speaker and members, is another demonstration of the government's unwavering commitment to building a justice system that is more accessible, more efficient, and more responsive to the needs of our people. As a Minister of State, I have had the opportunity to witness the ministry's continued efforts to improve access to justice through innovation, through reform, and through the expansion of alternative dispute resolution mechanisms. And this bill represents another important milestone in this journey. Members, justice is not measured solely by the outcome of a case. It is also measured by whether our ordinary Jamaican citizens can resolve their disputes fairly, promptly, affordably, and with dignity. As an attorney practicing for many years in rural Jamaica, I know that litigation can be lengthy, costly, and emotionally taxing. While the courts will always remain indispensable in the administration of justice, not every dispute needs to end up in the courtroom. In many instances,
Upgrade your vocal mix from this
How can we keep in touch?
to this.
How can we keep in touch if I can't even touch you?
Experience the latest vocal enhancing technology for yourself at the click of a button. You no longer have to spend hours trying to make your vocals sound professional. I've already done it for you with Rise Up Audio vocal presets. Start saving thousands of dollars by avoiding sound engineer fees, studio time, and expensive plugins by letting the presets do the work for you. Inspired by today's top artists, these presets will have you sounding radio ready, so there's no need to download new software. Download one for yourself now at riseupaudio.com.
a boundary dispute between neighbors or even between members of the same family over a parcel of land. And that is a daily occurrence in our rural courts. These are among the most common matters that come before the courts, particularly where you don't have proper documentation. Sometimes the documentation is limited, sometimes it is non-existent at all. Or you have in the courts a disagreement over a fence. Your fence is on my piece of land, a right of way, or where one property ends and the other property begins, and that can remain before the courts for years. We put it off because this one traveling, we put it off because the paper's not here, and it goes on and on. During that time, parties have to incur a lot of legal costs. I know people talk about costs now with mediation, but believe me, they're paying it in legal costs when you have to have this matter linger in the courts. And while they pay the costs, the relationships deteriorate. And what began sometime as a single disagreement you come over my fence line grows often into deep and lasting hostility. So it is through mediation, however, that those parties can come. They can sit around a table with an impartial mediator, openly discuss the issues, examine the surveys and any little piece of paper them have, or bring in brother or sister who was around at the time and can help, and work towards a practical solution that they themselves have crafted. They can own the discussion. It is not an attorney standing up or a judge at the top that dictates what happened. They work it out for themselves. So instead of having years of litigation, they may resolve the matter in weeks and months. Instead of exhausting their resources on prolonged legal proceedings, they hold on to their money. More importantly, instead of destroying relationships between neighbors or family members, they preserve the peace and goodwill that are so essential to our communities. So, Mr. Speaker and members of the House, that is really the true promise of mediation and what it is that the minister and the ministry is trying to bring here to us in this country to help our citizens. It is not simply just resolving a dispute. It is about restoring relationships, reducing hostility, and allowing our Jamaicans to move forward with dignity and respect. It doesn't matter what the disagreement is. We ought to learn and encourage each other to move forward with dignity and with respect. So, the Ministry of Justice and Constitutional Affairs have long recognized that improving access to justice requires more than simply building more courtrooms or appointing more judges. It requires providing our citizens with effective alternatives that are timely, affordable, and centered on the needs of our people who are seeking justice. The bill strengthens that vision for our country. By encouraging greater use of mediation, we can reduce unnecessary litigation, ease pressure on our courts, shorten the time taken to resolve disputes, and allow the judicial resources to be directed towards matters that truly require judicial determination. Most importantly, Mr. Speaker, mediation will empower our people. It gives individual ownership of the resolution process and enables them to craft practical solutions that work for their particular circumstances. Not a law that is set there that they have to fit in. They will discuss and find some way to resolve their differences. So, members, I want to use this opportunity to encourage all Jamaicans to embrace mediation as the first option wherever it is appropriate so to do, and to encourage all of us, but I don't think I need to encourage us. I feel that we do, all of us, despite the various suggestions, and there are suggestions that are made that we can take into account at committee stage. But I do believe that all of us as members support this bill. Choosing mediation is not about avoiding justice. It is about pursuing justice in a manner that is constructive, collaborative, and forward-looking. It demonstrates a willingness to listen, to understand, and to find common ground. These are qualities that strengthen not just our justice system, but our democracy and our society as a whole. So as we continue to advance constitutional and the justice sector reform, Legislation such as this bill reminds us that justice is ultimately about serving people. It is about ensuring that every Jamaican has meaningful access to fair, effective, and timely dispute resolution. Mr. Speaker and members of this House, as I said, I'm confident that this bill will make a lasting contribution to the administration of justice in Jamaica and to the promotion of a more peaceful, resilient, and cohesive society. I therefore recommend and ask that we pass this bill.
House Leader. Member from St. James West Central.
Mr. Speaker, I rise to support this bill entitled the Mediation Act. Having read the bill in its entirety, I believe that it is a welcome step in our alternative dispute resolution framework. The bill is well thought out and it is clearly written. I have taken note of concerns about overregulation. And while, as a general rule, I think in our jurisdiction there is a tendency to overregulate, this bill does not fall in that category. A requirement for registration or licensing without more does not equate to overregulation. I think much will depend on the rules that are to be made, the regulations. And I have every reason to believe that when those rules are made, that they will be facilitatory instead of restrictive. Mr. Speaker, providing for time frame for the conduct of any matter is something that always finds favor. In respect of mediation, I believe that it could be a little difficult because all matters must depend on their own circumstances, complexity, parties. And so it may be challenging to provide for the time frame within which mediation is to be completed. But the bill otherwise sets out time frame within which actions are to be taken, and I think it is quite commendable. In addition to all that is provided, I'm particularly taken with Part 9 of the bill, which makes provision for facilitated contract renegotiation. And it provides that a mediator may be appointed by parties to a contract to serve as a facilitator for facilitated contract renegotiation. It is such a welcome addition to the legal framework because we have so many examples of the need for renegotiation of contract, which would avoid breach of contract, delay, and everything else that comes with a genuine inability to perform a contract as initially agreed or negotiated. This bill binds the crown, and it is my hope that the government, when passed into law, will take advantage of this provision. Of course, Minister, you recognize that the prescribed forms will have to be done as soon as possible to ensure that once the bill is passed into law, the provisions can be utilized. But it is a forward step and a welcome step, and it has my support.
Mr. Speaker, I'm planning to close the debate, but the committee stage will be taken next week because there's some slight amendment as proposed by the member from Northeast St. Elizabeth, which I agree with some of them. I will speak to it. But the CPC, unfortunately, is not here because somehow she did not know that we're going to close today. So I will wait until next week to go to the committee stage where she will list the amendments so that the bill can be passed at the committee stage. But I want to thank the members who have contributed to what I believe will be a transformative bill for Jamaica. Let me deal with the members of the opposition first, starting with my friend and colleague from Northeast St. Elizabeth. I must tell you, I agree that we should use ordinary instead of habitual. And also that we should put at 11.2 or in lieu of payment 6 months. I don't know how that slipped me. So the CPC, I was in contact, and somehow we will address that at the committee stage. I don't agree with you, though, that the age should be reduced to 18. I think a mediator should be someone experienced. In fact, at one time, I thought it should be 25, but age of majority, 21. So I would say, let us leave it at 21, okay? Not a problem. But you see, and let me get straight to that point. Both the member from Southeast St. Anne and also the member from South and Southwest speak of regulation and whether or not certification means we're going to regulate mediators. The truth of the matter is that we want everybody to be a mediator. When you see a quarrel, when you see a dispute, you know, I hope people take the opportunity to learn about the principles, practice, and the strategies of mediation. So that whether it is in here, whether it is on the street, if the opportunity of a dispute arises, anybody should really, if they know a little about mediation, assist. So that the idea, as the member from Southeast St. Anne pointed out, mediation is time immemorial. You know, I mean, pastors do that counseling. You do that in the schools. The guidance council bring parties together. These are forms of mediation, and what we're hoping is that this mediation will promote it fully so that persons can actually be trained as mediators, even if they don't want to become certified. So indeed, the member from South St. Andrew, I have encouraged persons to learn about mediation. So I got the DRF, for example, 7 years ago, to train 600 JPs. None of them really want to be practicing mediators, but I wanted them to know about mediation. It's the same as I've said, which I started this week. I want about 20 persons in the Administrator General to be trained in mediation, because parties come there and quarrel and want to fight inside the office. So they will be mediators, they will be trained, they may not want to be certified, but at the end of the day, they would at least understand how they can practice mediation. And I hope all of us in here will learn about the practice of mediation and how it can help to really ease and solve disputes. Where the regulation will be, member, is those persons especially who are going to charge, and those who are referred by the Supreme Court or the parish courts. So you need for those mediators to be certified firstly, and we have a registry of them. And if community mediation takes off, or where business places have a problem and they want a trained, certified mediator to assist within the business, then they can usually look at the registry or get from a mediator service provider. At the moment, we only have one, the DRF, but we are hoping there will be others who can find a certified mediator to be able to assist the parties, and they can charge. So what that bill in particular does for the member from Southeast St. Anne, you can practice mediation, and everybody should. But if you're going to charge, you must be certified and registered. So that is the only regulation where persons who charge, they must be certified and on the registry. Anyone else who want to practice mediation can do so, but they must charge. Okay, that's the difference. Now, in relation to my friend from West St. Andrew, arbitration has not taken off, but as the member from South St. Andrew says, we really want Jamaica to be an arbitration mediation center, just like Singapore. And you have combinations of mediation and arbitration. For instance, you have MedArb, where the parties, once they agree to mediation, they can actually say, if we can't come to a settlement, they sign before and agree that the mediator can then be an arbitrator. So the arbitrator can make a decision. But that is with the consent of the parties. And so you have various combinations, MedArb, ArbMed. If in an arbitration you can't get along, you ask that the parties really try mediation before anything. But the essence of mediation is a win-win for the parties. The idea is that the parties can talk out the issues and come to a settlement that is satisfactory to both of them. Because if it is not satisfactory to both of them, then they don't have to sign anything. You move on. That's the end of it. You can go to court after that. And what the law provides is that if you participate in mediation, and as the member from South Trelawny say, try it before you start an action in court. Because if you try it and you succeed, you save a lot of costs going to court. But if you fail, nothing in the mediation can be brought up in court. All of that can be dealt with. And so my friend from Minister Tufton has pointed out that we need more of this community mediation to keep families from fighting one another, neighbors from fighting one another. Huge amount of domestic violence, and actually violence, is because people can't settle their differences. And this is why, colleagues across this parliament, we all have to think about how we can promote this mediation. Because if we do a lot of domestic disputes, not even so much commercial, because they can settle their contracts and what have you. And we urge them to use it. But the domestic disputes, the homes, unfortunately, are becoming war zones. And we need for these families to really seek help. And we're hoping with restorative justice, victim services, and no mediation, parties have more access to services which can assist them. Now, the member from Hanover mentioned about time. Truth of the matter, you can't really set a time.
Imagine being able to build an app with your name on it, just by thinking about it. Meet Base 40.
But the truth of the matter is, it depends on the complexity of the matter. I suspect that there's complex matters that can take days. There are simple matters that can take an hour. Right? Extension, no. So one of the reasons also, members, why I want for the regulation to be there is that the Ministry of Justice have started 3 years ago to pay mediators. And it came about because when I urged the Chief Justice to urge the parish court judges to send people to mediation, he looked at me squarely and said, most of these litigants can't even afford bus fare. How can they afford a mediator? And the mediators were charging $5,000 for each side. So we started out 3 years ago paying each side $5,000, but now we are paying $10,000 each side if they go through the means test and they can't afford it. And We have moved over the last 3 years from 10 million, 13 million, and 20. We paid out because mediation over 4,000 mediation, odd percent of them were settled. And the mediators, when they saw the bill, they said, thank you, Mr. Chow. Promote it more. These are the mediators who make it some good money. I mean, you know, and the truth of the matter is that we want more persons to be trained in mediation. I was in touch with the head of the DRF. He says that there are about 17 trainers, and we want over the utility secretary. You have more conflicts in this department than you can imagine. And we want teachers, at least 4 or 5 teachers in every school to be trained in mediation. And we're not saying that they should be certified. But if they do the training, well,
Every choice we make can build bridges or burn them. Let's choose peace in our words, our action, and our
Yeah. Yeah. Right. That's right. Hey.
Your job to contact your employees. It's easy when you visit the MP tracker on JAMP.org. This is how we can do our part